It's everyone's friend, it's Tyler. It's everyone's friend, it's Tyler.
Hey guys, Tyler here. Like with the case of Louisiana, as well as the case of Oklahoma, Illinois has decided to display the Ten Commandments as well. The Freedom from Religion Foundation demands Illinois County to remove the Ten Commandments display from the courthouse. And this right here is actually the image of the Ten Commandments. And I also have a Bible verse underneath the statue. It says right here that the Freedom from Religion Foundation was informed that the Ten Commandments display was recently installed at the courthouse in Mount Vernon III. The display is nearly 6.5 feet tall and sits in the center of the first floor lobby. The display includes a Protestant version of the Ten Commandments given its particular language and numbering. At the bottom of the display is the biblical quote for Proverbs 21, verse 15, which reads, "When justice is done, it is a joy to the righteous, but terror to the evildoers." When I saw that newsletter directly from the Freedom from Religion Foundation, it reminded me so much about what happened back in 2005 for a particular Supreme Court case. Now, the Supreme Court case back in 2005 was something that was known as MCRA County versus American Civil Unions. Now, the context for this particular court case was that executives of two counties posted a version of the Ten Commandments on the walls of their courthouse. After suits were filed charging violations of the Establishment Clause, the legislative body of each county adopted a resolution calling for a more expensive exhibit meant to show the commandments are Kentucky's President Legal Code. The result in each instance was a modified display of the commandments surrounded by text containing religious references as their sole common element. Here's an audio segment that comes directly from the Supreme Court about the end results about what occurred.
Neutrality has long been a touchstone of our cases. And when the government is understood to take sides purposely in religious matters, there can be no neutrality, but only the social tension that the framers sought to avoid in drafting the Establishment Clause. We thus reaffirm today that government action predominantly intended to advance religion is not permitted under the Establishment Clause. Applying this principle to the case at hand, we reach the following conclusions. 25 years ago, in the case of Stone v. Graham, we recognized and held something pretty obvious, that the Ten Commandments are an inherently religious statement. That does not, to be sure, mean that every governmental display of the commandments is unconstitutional. Context matters, and where the display serves some educational or other predominantly secular goal, the display can be constitutional. In fact, Moses and the commandments are displayed in this very courtroom up on the South Frieze. But Moses stands there in the company of other lawgivers, both great and secular, demonstrating that the display is about lawgivers, not about religion, and was not the product of some religious objective. In the Kentucky courthouses, however, the first commandments display consisted of the text of the commandments in isolation. Shorn of any integration into a secular project, the commandments' text, including such prohibitions as "Thou shalt have no other gods before me," leads to the inescapable conclusion that the counties intended to put out a religious message. The second display only amplified this religious message, and indeed the counties make no attempt to defend it, describing the second display as dead and buried. That display, with its explicitly sectarian resolution and surrounding religious references, could leave no doubt that the counties intended to make a religious statement. In evaluating the third display, we have to consider the two displays that immediately preceded it. We think that the district court was justified in concluding that the counties had not shown a new secular educational purpose. The counties did not repeal the religious resolution that accompanied the second display. In fact, the third quoted the religious prohibitions of the commandments in even more detail than the preceding ones had done. The county's educational claims were also undermined by the scattershot nature of the supposedly foundational materials accompanying the commandments, for example, the picture of Lady Liberty, and the overstated description of the commandment's influence on American law. In upholding the district court's conclusions that the counties still had a predominantly religious purpose in erecting the third displays, we do not hold that past unconstitutional purposes forever taint future government action. Instead, we acknowledge only that stated purposes must be creditable before they will be credited, and that the district court, which was familiar with the facts in this case, was warranted in concluding that the counties had not adopted a new purpose.
There was also a court case that was done back in 1943 that was titled West Virginia State Board of Education versus Bernett. For that particular case, Justice Robert Jackson said right here, if there is any fixed stars in our constitutional coalition, it is no official, high or petty, can prescribe what shall be orthodox in politics, naturalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. Given the recent Supreme Court case that occurred back in 2005, as well as the fact that there was also a case that said in the 1940s that more or less that students cannot be compelled directly to actually follow a certain belief system for religion, it is safe to say that what happened in the state of Illinois for this particular case is very much anti-constitutional based upon the Supreme Court rulings. But what do you guys think about this whole entire situation? Tell me in the comment section down below. And as always, I'll see you guys in the next video.